Hurlman versus Rice, Second Circuit, 1991. A due process violation occurs when a state-required breakup of a natural family is founded solely on a best interests analysis that is not supported by the requisite proof of parental unfitness. Quillian versus Walcott, 434 U.S. 246 to 255, 1978. Preface. This is a guide to your constitutional protections in the context of an investigation of alleged child abuse and neglect by Child Protective Services. CPS. Every state has variances of CPS in one form or another. Some are called DCF, DHS, DSS, DCYS, DCFS, HRS, CYS, and FIA, collectively known as CPS. For the purposes of this handbook, the material in this handbook should be supplemented by your own careful study of the 4th and 14th Amendment and other constitutional protections that are guaranteed even in the context dealing with CPS. The intent of this handbook is to inform parents, caregivers, and their attorneys that they can stand up against the CPS and juvenile judges when they infringe upon the rights of both parents and children. As you read this handbook, you will be amazed what your rights are and how CPS conspires with the Assistant Attorney General, AAG, who then in turn has the judge issue warrant orders that are unlawful and unconstitutional under the law. Contrary to what any CPS officials, the AAG, juvenile judge, or any social workers may say, they are subject to and must yield to the 4th and 14th Amendment, just like police officers according to the Circuit and District Courts of the United States and the Supreme Court. CPS workers can be sued for violations of your 4th and 14th Amendments. They lose their immunity by those deprivation of rights under color of law and must be sued in their official and individual capacity in order to succeed. Oh, about the authors. The authors of this book are not attorneys and do not pretend to be attorneys. Authors were victims of a false report and were falsely accused by DCF in Connecticut without conducting a proper investigation. The authors fought back for 8 months against the corrupt organization whose order of the day was to deny them their 4th, 6th, 14th Amendment rights and to fabricate false charges without evidence. DCF's charges and petition to the court was nothing more than baseless allegations, never evidence. DCF withdrew the fraudulent petition on December 18, 2002, admitting they had no evidence. The fact of the matter is they never had any evidence, but abused the authors and their children for an 8-month period. As a direct result of the false charges, and with manufacturing of evidence and violating the authors' 1st, 4th, 6th, 9th, and 14th Amendment rights, the authors filed a lawsuit in January 2003 in federal court in the District of Connecticut. There are 28 defendants in this civil action, and the authors are representing themselves pro se. The authors have never been convicted of any child abuse or neglect, nor are there any investigations ongoing. The authors have 3 children, a 16-year-old and 11-year-old twins. The authors' goals are that not another child is illegally abducted from their family, and that CPS and the juvenile judges start using common sense before rushing to judgment and to conduct their investigations the same as do police in order to be constitutionally correct and legal, and that CPS must, by law, comply with the warrant clause as required by the Constitution and the federal courts, whereas they are government officials and are subject to the Constitution as are the police. There are no exceptions to the Constitution for the CPS. Introduction. You, as a parent or caregiver, must know your rights and be totally informed what you have a legal right to have and to express. Whether you are a parent caught up in a very oppressive, abusive, and many times unlawful actions of CPS, or if you have never been investigated by the CPS. Many individuals come to the wrong conclusion that the parents must have been abusive or neglectful in order for CPS to investigate. But this is just a myth. The fact of the matter is that over 80% of the calls that are called in to CPS are false and bogus. Another myth is that CPS can conduct an investigation in your home without your consent and speak to your child without your consent. CPS employees will lie to you and tell you they do not need your consent. The fact of the matter is they absolutely need your consent. Another myth is that CPS can conduct an investigation in your home without your consent and speak to your child without your consent. CPS employees will lie to you. They will tell you they do not need your consent. The fact of the matter is they absolutely need your consent to come into your home and speak with your children. If there is no exigent circumstances or imminent danger to your children with probable cause, credible witness, to support a warrant, CPS anywhere in the United States cannot lawfully enter your home and speak with you or your children. In fact, it is illegal, and you can sue the social worker and the police who assist them, and they both lose immunity from being sued. If CPS lies to the AAG and the judge in order to get a warrant/order, and you can prove it, that is also a 4th and 14th Amendment rights violation, which is a civil rights violation under Supreme Court 1983, and conspiracy against rights covered under Supreme Court 1985. If a CPS official knocks on your door and has no legal warrant and you refuse them entry, and the worker then threatens you with calling the police, this is also illegal and unlawful, and both lose immunity. This is coercion, threatening, and intimidation tactics. Even if the police only got the door open so the CPS official can gain entry, both can be sued. Remember, CPS officials will not tell you your rights. In fact, they're going to do everything in their power, including lying to you, threatening you with police presence, telling you that you have to let them in. The police may even threaten you to let CPS in because you are obstructing an investigation. Many police officers do not realize that the CPS must comply with the warrant clause of the 14th Amendment or be sued for violating it. CPS does not have a legal right to conduct an investigation of alleged child abuse or neglect in a private home without your consent. In fact, removing a child from your home without your consent, even for several hours, is a seizure under federal law. Speaking to your children without your consent is also a seizure under the law. If CPS cannot support a warrant and show that the child is in imminent danger, along with probable cause, CPS cannot enter your home and speak with your children. Remember, anonymous calls into CPS are never probable cause under the warrant clause. And even if they got a name and number from the reporter on the end of the phone, that also does not support probable cause. Under the law, CPS must by law investigate the caller to determine to see if he or she is the person who they say they are and that what they say is credible. The call alone, standing by itself, is insufficient to support probable cause under the law. Many bogus calls are made by disgruntled neighbors, ex-spouses, someone wanting to get revenge. There are a lot of ugly people in this world. So CPS needs to show due diligence, as do police, to get sworn statements. All CPS agencies all across the country have a much exaggerated view of their power. And what you think is abuse or neglect is or is not. CPS has a totally different definition. The definition is whatever they want it to be. DCF will lie to you. Mark my word, they will tell you that they can do anything they want and they have total immunity. Tell that to the half a dozen social workers sitting in jail in California that lied to the judge. We will discuss this in further detail on what CPS and the police can do and cannot do. Section 1. Never, ever, ever, ever trust anyone from the CPS. You have to understand that CPS will not give you or your spouse a Miranda warning, nor do they have to. If CPS shows up at your door and tells you they need to speak with you and your children, you have the legal right to deny them entry. But before they leave, you should bring your children to the door but never open it. Instead, show them the children are not in imminent danger and that they are fine. If you do not at least show them your children, they could come back with an unlawful and unconstitutional warrant even though your children are not in imminent danger. Everything CPS sees and hears is written down and eventually given to the AAG for possible prosecution. You also need to know if the focus of the investigation is on your spouse or significant other, you may think that you may not be charged with anything and that you are the non-offending spouse. Wrong. If your spouse gets charged with anything, you are probably going to get charged with allowing it to happen. Really? So if a spouse gets the bright idea and lies and makes things up, he or she is also confessing that he allowed whatever he or she alleges. What you say will more than likely not be written down the way you said it or meant it. For example, the CPS worker asked the wife, "Does your husband yell at the children?" Your response could be, "Once in a while." Then they ask, "Does he yell at you and argue with you?" Your response could be, "Yes, we argue sometimes, and he may raise his voice." The next question is, "Does your husband drink alcohol?" Your response could be, "Yes, he has several drinks a week." Now, let's translate those to the responses and see what CPS may write in her paperwork. When the father drinks, he yells at his children and wife, and the wife is a victim of domestic abuse. This is a far cry from what really took place in that conversation. CPS routinely will take what you saw out of context and actually lie in the reports in order to have a successful prosecution. That's it. Something similar happened to the authors, where DCF employees lied in front of the judge and said the husband was a victim of domestic violence, even though all 5 members of the family stated clearly that there was never any domestic violence. The husband would like to know when this occurred because he wasn't there. They will also misrepresent the condition of your home, as did DCF with us. Even though you were sick or injured and hadn't had the chance to straighten anything out, CPS will not put anything exculpatory in the record, so anyone that reads her notes will read, "The house was a mess and cluttered." Never give them a chance to falsify the record or twist your words. The best advice we can offer is, before letting any CPS official in, if you choose to do so, is to tell them you want your attorney there when they come and schedule a time for that. Remember, CPS could care less about your rights or your children's constitutional rights. Removing a child from a safe home is more harmful than most alleged allegations, as stated by many judges. They will lie and say they have to come in, or you have to comply. Remember, CPS has no statutory authority to enter your home when no crime has been committed. They are trained to lie to you in order to get in any way they can, and this comes from interviewing employees at the DCF. Do not sign anything or agree to anything. Even if you're not guilty and you agree to go through some horse and pony show, that is used against you as if you admitted to it. Woo! If I would have known this. Woo. Woo. Good stuff. Section 2. Are all CPS workers in the United States subject to the 4th and 14th Amendment? Yes! Yes, they are. The 4th Amendment is applicable to DCF investigators in the context of an investigation of alleged abuse and neglect, as are all government officials. This issue is brought out best in Walsh v. Erie County Department of Job and Family Services, 301, Court v. 7588. The social worker argued the 4th Amendment was not applicable to the activities of their social worker employees. The social worker claimed, "Entries into private homes by child welfare workers involve neither searches nor seizures under the 4th Amendment, and thus can be conducted without either a warrant or probable cause to believe that a child is at risk of imminent harm." The court disagreed. Hi! Despite the defendant's exaggerated view of their powers, the 4th Amendment applies to them, as it does to all other officers and agents of the state who request to enter, however benign or well-intentioned, are met by a closed door. The court also stated the 4th Amendment's prohibition on unreasonable searches and seizures applies whenever an investigator, be it a police officer, a DCFS employee, or any other agent of the state, responds to an alleged instance of child abuse, neglect, or dependency. The social worker's first argument shot down by the court. They then argued that there are exceptions to the 4th Amendment and that the situation was an emergency. The defendants argue their entry into the home, even absent voluntary consent, was reasonable under the circumstances. They point to the anonymous complaint about clutter on the front porch and the plaintiff's attempt to leave. Woo! These circumstances, the defendants argue, created an emergency situation that led Darnold and Brown reasonably to believe that the Walsh children were in danger of imminent harm. Thus is the old emergency excuse that has been used for years by social workers. The court again disagreed and ruled there is nothing inherently unusual or dangerous about cluttered premises, much less anything about such vaguely described conditions that could manifest imminent or even possible danger to harm young children. If a household clutter justifies warrantless and threats of removal of children or arrest or citation of their parents, few families are secure and few homes are safe from unwelcome and unjustified intrusion by state officials and officers. The court went on to rule they have failed to show that any exigency that justifies warrantless entry was necessary to protect the welfare of the plaintiff's children. In this case, a rational jury that justifies warrantless entry was necessary to protect the welfare of the plaintiff's children. In this case, a rational jury could find that not evidence points to the opposite conclusion and a lack of sufficient exigent circumstances to relieve the state actors here of the burden of obtaining a warrant. The social worker's second argument, shot down by the court. The social workers then argued that they are obligated under law to investigate a new reported case of child abuse that supersedes the Fourth Amendment. They argued against these fundamental rights. The defendants contend that Ohio's statutory framework for learning about and investigation allegations of child abuse and neglect supersede their obligations under the Fourth Amendment. They point principally to the Supreme Court ruling 2151-421 of the Ohio Revised Code as authority for professionals and persons who work with children or provide child care to report instances of apparent child abuse or neglect. This is the old mandatory reporter excuse. The court disagreed and ruled the defendant's argument that the duty to investigate, created by Supreme Court 2151.421 F1, exempts them from the Fourth Amendment misses the mark because not having received a report described in Supreme Court 2151.421 A1, they were not and could not have been conducting an investigation pursuant to 2151.421 F1. The social worker's third argument shot down by the court. The court continues with their chastisement of the social workers. There can be no doubt that the state can and should protect the welfare of children who are at risk from acts of abuse and neglect. There likewise can be no doubt that occasions arise calling for the immediate response, even without prior judicial approval, but those instances are the exception. Otherwise, child welfare workers would have a free pass into any home in which they have an anonymous report or poor housekeeping, overcrowding, and insufficient medical care, and thus perception that children may be at some risk. The court continues. The anonymous phone call in this case did not constitute a report of child abuse or neglect. The social workers Darnold and Brown claimed that they were immune from liability, claiming qualified immunity because they had not training in Fourth Amendment law. In other words, because they thought the Fourth Amendment did not bind them, they could not be sued for their mistake. The police officers, Chandler and Kish, claimed that they couldn't be sued because they thought the social workers were not subject to the Fourth Amendment and they were just helping the social workers. The court disagreed and ruled that subjective basis for their ignorance and actions in violation of the Fourth Amendment does not relieve them of the consequences of that ignorance and those actions. The court then lowers the boom by stating the claims of the defendants, Darnold, Brown, Chandler, and Kish, of qualified immunity are therefore denied. The Ninth Circuit Court said parents have the constitutional right to be left alone by the CPS and the police. Good thing. The Ninth Circuit Court of Appeals case, Calabretta versus Floyd, Ninth Circuit, 1999, involves whether a social worker and a police officer were entitled to qualified immunity for a coerced entry into a home to investigate a suspected child abuse. Entering her house against the mother's will to examine her child for bruises. Good holds that a search warrant or exigent circumstances, such as a need to protect the child against imminent danger of serious bodily injury, was necessary for an entry without consent, and the anonymous tip claiming bruises was in the case insufficient to establish special exigency. The Ninth Circuit further opined, O-P-I-N-E-D. I didn't know that was a word. In Wallison versus Spencer, 202 F3D 1126, Ninth Circuit, 2000, that because the swing of every pendulum brings with it potential adverse consequences, it is important to emphasize that in the area of child abuse, as with the investigation and prosecution of all crimes, the state is constrained by substantive and procedural guarantees of the Constitution. The fact that the suspected crime may be heinous, whether it involves children or adults, does not provide cause for the state to ignore the rights of the accused or any other parties. Otherwise, serious injustices may result. In the cases of alleged child abuse, government failure to abide by constitutional constraints may have deleterious long-term consequences for the child and, indeed, for the entire family. Ill-considered and improper government action may create significant injury where no problem of any kind previously existed. This was the case involving DCF in Connecticut. Many of their policies are unlawful and contradictory to the Constitution. DCF has unlawful policies giving workers permission to coerce, intimidate, and to threaten innocent families with governmental intrusion and oppression with police presences to squelch and put down any citizen who asserts their Fourth Amendment rights by not allowing an unlawful investigation to take place in their private home when no imminent danger is present. DCF is the moving force behind the ongoing violations of the federal law and violations of the Constitution. This idea of not complying to the 4th and 14th Amendment is so impregnated in their statutes, policies, practices, and custom. It affects all and what they do, and they take on the persona of the feeling of exaggerated power over parents and that they are totally immune and can basically do anything they want, including engaging in deception, misrepresentation of the facts, and lying to the judge. This happens thousands of times every day in the United States, where the end justifies the mean, even if it's unlawful, illegal, and unconstitutional. We can tell you stories for hours where CPS employees committed criminal acts and were prosecuted and went to jail and/or was sued for civil rights violation. CPS workers have lied in reports, court documents, and asked others to lie, kidnapped children without court order, crossed state lines impersonating police, and then kidnapping children and were prosecuted for that, and including a number of cases where the caseworker killed the child. Oh my God. Oh my God. It is sickening on how many children are subject to abuse, neglect, and even killed at the hands of the Child Protective Services. And they've got some numbers here while in the custody of, and this is the DCF in Connecticut, and I'm not sure what year this was, but it's really, the numbers point to CPS being more detrimental than good. I can show you this little chart. Maybe I'll put it on the video or something. Number of cases per 100,000 children in the United States. These numbers come from the National Center on Abuse and Neglect. Right there. Oh, yeah, I don't know if you can read that. Anyway. I should probably do that one. Yeah, let's stop that one. It is sickening on how many children are subject to abuse, neglect, and even killed at the hands of the Child Protective Services. Imagine that 6.4 children died at the hands of the agencies that are supposed to protect, and only 1.5 at the hands of parents per 100,000 children. Wow. CPS perpetrates more abuse, neglect, and sexual abuse, and kills more children than parents in the United States. If the citizens of this country hold CPS to the same standards that they hold parents to, no judge should ever put another child in the hands of any government agency, because CPS nationwide is guilty for more harm and death than any human being combined. CPS nationwide is guilty for more human rights violations and death of children than the homes they took them out of. When are the judges going to wake up to see that they are sending children to their death and a life of abuse when children are removed from the safe homes at the mere opinion of a bunch of social workers? Section 3. The Fourth Amendment's impact on child abuse investigations. The United States Court of Appeals for the Ninth Circuit said it best. The government's interest in the welfare of children embraces not only protecting children from physical abuse, but also protecting children's interest in the privacy and dignity of their homes and in the lawfully exercised authority of their parents. Calabretta v. Floyd, 189 F3D 808, 1999. This statement came in a case which held that a social worker who, in pursuit of a child abuse investigation, invaded a family home without a warrant, violated the Fourth Amendment rights of both children and parents. Upon remand for the damages phase of the trial, the social workers, the police officers, and the governments that employed them settled this civil rights case for $150,000. Yeah, buddy. Contrary to the assumption of hundreds of social workers, the Ninth Circuit held that the Fourth Amendment applies just as much to the child abuse investigation as it does to any criminal or other government investigation. Social workers are not exempt from the requirements of the Fourth Amendment when they act alone. They are not exempt from its rules if they are accompanied by a police officer. And police officers are not exempt from the requirement even if all they do is get the front door open for the social worker. This would be intimidation, coercion, and threatening. The general rule is that unreasonable searches and seizures are banned. But the second part of the rule is the most important in this context. All warrantless searches are presumptively unreasonable. Section 4. When is consent not consent? If a police officer says, "If you don't let us in your home, we will break down your door," a parent who then opens the door has not given free or voluntary consent. If a social worker says, "If you don't let me in the home, I will take your children away," a parent who then opens the door has not given free and voluntary consent. If a social worker says, "I will get a warrant from the judge or I will call the police if you do not let me in," negate consent. Any type of communication which conveys the idea to the parents that they have no realistic alternative but to allow entry negates any claim that the entry was lawfully gained through the channel of consent. DCF's policy clearly tells the social worker that they can threaten parents even if the parents assert their Fourth Amendment rights. Ooh. The Fourth Amendment does not put a barrier in the way of a social worker who has reliable evidence that a child is in imminent danger. For example, if a hotline call comes in and says, "My name is Mildred Smith. Here's my address and my phone number. I was visiting my grandchildren this morning and I discovered that one of my grandchildren, Johnny, age 5, is being locked in his bedroom without food for days at a time. He looked pale and weak to me." The social worker certainly has evidence of exigent circumstances and is only one step away from having probable cause. Since the report has been received over the telephone, it is possible that the tipster is an imposter and not the child's grandmother. A quick verification of the relationship can be made in a variety of ways, and once verified, The informant would satisfy the legal test of reliability, which is necessary to establish probable cause. Anonymous phone calls fail the second part of the two-prong requirement necessary of exigent circumstances and probable cause for a warrant or order. Anonymous phone calls cannot stand the test of probable cause as defined within the 14th Amendment and would fail in court.
Oh, you plugged in though, really? You plugged in right now. Come on. Oh, come on. Oh, don't die on me now. Laddie, don't die on me. Shit.
Oh. Since the report has been received over the telephone, it is possible that the tipster is an imposter and not the child's grandmother. A quick verification of the relationship can be made in a variety of ways, and once verified, the informant would satisfy the legal test of reliability, which is necessary to establish probable cause. Anonymous phone calls fail the second part of the two-prong requirement of exigent circumstances and probable cause for a warrant or order. Anonymous phone calls cannot stand the test of probable cause as defined within the 14th Amendments and would fail in court on appeal. The social workers would lose their qualified immunity for the deprivation of rights and can be sued. Many social workers and child protective services lose their cases in court because their entry into the homes was in violation of the parents' civil rights because the evidence in their possession did not satisfy the standard of probable cause. It is not enough to have information that the children are in some form of serious danger. The evidence must also pass a test of reliability that our justice system calls a probable cause. In HR versus State Department of Human Resources, 612 SO 2D477, ALACT APP, 1992. I'm guessing Alabama court, appellate, I don't know. The court held that an anonymous tip standing alone never amounts to probable cause. The Calabretta court held the same thing, as have numerous and other decisions which have faced the issue directly. The Fourth Amendment itself spells out the evidence required for a warrant or entry order. No warrant shall issue but on probable cause. The United States Supreme Court has held that courts may not use a different standard other than probable cause for the issuance of such orders. Griffin versus Wisconsin, 483 U.S. 868, 1987. If a court issues a warrant based on an uncorroborated anonymous tip, the warrant will not survive a judicial challenge into the higher courts. Anonymous tips are never, ever, ever, ever probable cause. Children are not well served if they are subjected to investigations based on false allegations. Little children can be traumatized by investigations in ways that are unintended by the social worker. However, to a small child, all they know is that a strange adult is taking off their clothing while their mother is sobbing in the next room in the presence of an armed police officer. This does not seem to a child to be a proper invasion of their person. Quite different. For example, from an examination by a doctor when their mother is present and cooperating. The misuse of anonymous tips is well known. Personal vendettas, neighborhood squabbles, dispute on the little league field, child custody battles, revenge, nosy individuals who are attempting to impose their views on others, are turned into maliciously false allegations breathed into a hotline. There's some really ugly people in this world. Decency, security, and liberty alike demand that government officials shall be subject to the rules of conduct that are commands to the citizen. In a government of laws, existence of government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, omnipresent teacher, for good or ill. It teaches the whole people by example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. U.S. versus Olmstead, 277, U.S. 438, 1928. Justice Brandeis. We, the people of the United States, are ruled by law, not by feelings. If the courts allow states and their agencies rule by feelings and not the law, we become a nation without the law that makes decisions based on subjectivity and objectivity. CPS has been allowed to bastardize and emasculate the Constitution and the rights of its citizens to be governed by the rule of men rather than the rule of law. It is very dangerous when governmental officials are allowed to have unfettered access to citizens' homes. It is also very dangerous to allow CPS to violate the confrontation clause in the Sixth Amendment, where CPS hides, conceals, and covers up the accuser/witness who made the report. It allows those individuals to have a safe haven to file fraudulent reports, and CPS aids and abets in this violation of fundamental right. All citizens have the right to know the accuser/witness in order to preserve the sanctity of the rule of law, and that the Constitution is supreme law of the land. Section 5. It is illegal and unconstitutional practice for CPS to remove children solely because they saw a parent was a victim of domestic violence. What? Yes, it's illegal and unconstitutional practice to remove children, which results in punishing the children and the non-offending parent. In a landmark class action suit in the U.S. District Court, Eastern District of New York, U.S. District Judge Jack Weinstein ruled on Nicholson v. William, case number 00CV2229. This suit challenged the practice of New York City's administration for children's services by removing the children of battered mothers solely because the children saw their mothers being beaten by the husbands or boyfriends. Judge Weinstein ruled that the practice is unconstitutional, and he ordered for it to stop. Are parents guilty of maltreatment or emotional neglect if the child witnesses domestic violence? Not according to Judge Weinstein's ruling and to the leading national experts. During the trial, several leading national experts testified on the impact on children of witnessing domestic violence and the impact on children of being removed from the non-offending parent. Views of experts and effects of domestic violence on children are defining witnessing domestic violence by children as maltreatment or emotional neglect is a mistake. Ooh, people make mistakes. CPS makes a lot of them. Great concern regarding how increased awareness of children's exposure to domestic violence and associated problems is being used. Concerned about the risk adult domestic violence poses for children, some protective Concerned about the risk adult domestic violence poses for children, some child protection agencies in the United States appear to be defining exposure to domestic violence as a form of child. Defining witnesses. I have definitely get into that one. Start in the great concern how increased awareness of children's exposure and associated problems is being used. Concerned about the risk adult domestic violence poses for children, some child protection agencies in the United States appear to be defining exposure to domestic violence as a form of child. Defining witnessing as maltreatment is a mistake. Doing so ignores the fact that large numbers of children in these studies showed no negative development problems, and some showed evidence of strong coping abilities. Automatically defining witnessing as maltreatment may also ignore the battered mother's efforts to develop safe environments for their children and themselves. The effects of removals of children and on the non-offending parent. Dr. Wolf testified that disruptions in the parent-child relationship might provoke fear and anxiety in a child and diminish his or her sense of stability and self. TR 565-67. He described the typical response of a child separated from his parent. When a young child is separated from a parent unwillingly, he or she shows distress. At first, the child is anxious and protests vigorously and angrily. Then he falls into a sense of despair, though still hypervigilant, looking, waiting, and hoping for her return. A child's sense of time factors into the extent to which a separation impacts his or her emotional well-being. Thus, for younger children whose sense of time is less keenly developed, short periods of parental absence may seem longer than for older children. TR 565-65. See also example 141b. Ooh, it looks like part of this is missing here. Stated that taking a child whose greatest fear is separation from his or her mother, and in the name of protecting that child by forcing on them what is in effect their worst nightmare, is tantamount to pouring salt on an open wound. Another serious implication of removal is that it introduces children to the foster care system, which can be much more dangerous and debilitating than the home situation. Dr. Stark testified that foster homes are rarely screened for the presence of violence and that the incidence of abuse and child fatality in foster homes is double that in the general population. TR 1596, example 122 at 3-4. Children in foster care often fail to receive adequate medical care. Foster care placements can disrupt the child's contact with community, school, and siblings. Dr. Pelkovitz stated that taking a child... Yeah, I just already read that. I swear, that's like written twice. Weird. On the same page. Let's start that one. Section 6. Do children have legal standing to sue CPS for their illegal abduction from their home and violating their 4th and 14th Amendment right? Yes! Yes, they do. Children have standing to sue for their removal after they reach the age of majority. Parents also have legal standing to sue if CPS violated their 4th and 14th Amendment rights. Children have a constitutional right to live with their parents without government interference. What? Really? Great stuff. Good to know. It's too late for a lot of people, but it's good to know that. Brokaw versus Mercer County, 7th Circuit, 2000. A child has constitutionally protected interest in the companionship and society of his or her parents. Ward versus San Jose, 9th Circuit, 1992. State employees who withhold a child from her family infringe on the family's liberty of familial association. KH through Murphy versus Morgan, 7th Circuit, 1990. The forced separation of a parent from a child, even for a short time, represents a serious infringement upon the rights of both. JB versus Washington County, 10th Circuit, 1997. Parents' interest is of the highest order, and the court recognizes the vital importance of curbing overzealous suspicion and intervention on the part of the healthcare professionals and government officials. Thomason versus Scan Volunteer Services Incorporated, 8th Circuit, 1996. You must protect you and your children's rights. CPS has no legal right to enter your home or speak to you or your child when there is no imminent danger present. Know your choices. You can refuse to speak to any government official, whether it is the police or CPS, as long as there is an open criminal investigation. They will tell you what they are involved with is a civil matter and not a criminal matter. Don't you believe it? There's nothing civil about allegations of child abuse or neglect. It is a criminal matter disguised as a civil matter. Police do not get involved in civil matters if it truly was one. You will regret letting them into your home and speaking with them like thousands of other parents who have gone through this. Ask a friend, family member, or someone at work. They will tell you if you agree to services, they will leave you alone. Or you can get your kids back. Refusing them entry is not hindering an investigation. It's Fourth Amendment protection, and CPS or the juvenile judge can't abrogate that right as long as your children are not in imminent danger. Tell them to go packing. Do not sign. Do not sign anything. Do not sign anything. It will come back to be used against you in any possible kangaroo trial. And I can tell you from first-hand experience, they will use anything. If you say, I need some help with my rent, they're going to say, she's going to lose her home. Of course, after they don't help you. I'm just saying. Your children's records are protected by FERPA and HIPAA regarding your children's educational and medical records. They need a lawful warrant, like the police under the warrant clause, in order to seize any records. If your child's school records contain medical records, then HIPAA also applies. When the school or doctor sends records to CPS or allows them to review them without your permission, both the sender and receiver violated the law. You need to file a HIPAA complaint on the sender and the receiver. A PDF version is http://www.hhs.gov/ocr/howtofileprivacy.pdf. Remember, you only have 180 days, which that's not a lot, from the time you found out about it. Tell them they need a lawful warrant to make you do anything. Don't do anything. Don't sign anything. Don't let them in without a warrant. The CPS has zero power, no power. They have no power at all. Do not agree to a drug screen or a psychological evaluation. I made these mistakes, okay? Section 7, Family Rights. The state may not interfere in child rearing decisions when a fit parent is available. What? Yeah. Troxel versus Granville, 530 U.S. 57, 2000. A child has a constitutionally protected interest in the companionship and society of his or her parent. Children have standing to sue for their removal after they reach age of majority. Children have a constitutional right to live with their parents without government interference. The private fundamental liberty interest involved in retaining custody of one's child and integrity of one's family is the greatest importance. State employees who withhold a child from her family may infringe on the family's liberty of familial association. Social workers could not deliberately remove children from their parents and place them with foster caregivers when the officials reasonably should have known such an action would cause harm to the child's mental or physical health. Ugh, sickening. These people are so sickening. The forced separation of a parent from a child, even for a short time, in this case 18 hours, represent a serious infringement upon the rights of both. JB versus Washington County, 10th Circuit, 1997. Absent extraordinary circumstances, a parent has a liberty interest in familial association and privacy that cannot be violated without adequate pre-deprivation procedures. Malik versus Arapahoe City, Department of Social Services, 10th Circuit, 1999. Parent interest is of the highest order, and the court recognizes the vital importance of curbing overzealous suspicion and intervention on the part of the healthcare professionals and government officials. Section 8. Warrantless entry. The mere possibility of danger does not constitute an emergency or exigent circumstance that would justify a forced warrantless entry and a warrantless seizure of a child. Hurlman versus Rice, 2nd Circuit, 1991. A police officer and social worker may not conduct a warrantless search or seizure in a suspected child abuse case, absent exigent circumstances. Defendants must have a reason to believe that life or limb is in immediate jeopardy and that the intrusion is reasonably necessary to alleviate the threat. Searches and seizures in investigation of a child neglect or child abuse case or at a home are governed by the same principles as other searches and seizures at a home. Good versus Dauphin County Services, 3rd Circuit, 1989. The Fourth Amendment protection against unreasonable searches and seizures extends beyond criminal investigations and includes conduct by social workers in the context of a child neglect abuse investigation. Lenz versus Winborn, 11th Circuit, 1995. The protection offered by the Fourth Amendment and by our laws does not exhaust itself once a warrant is obtained. The concern for the privacy, safety, and property of our citizens continues, and it is reflected in knock and announce requirements. United States versus Becker, 929 F2D, 9th Circuit, 1991. Making false statements made to obtain a warrant when the false statements were necessary to the finding of probable cause on which the warrant was based violates the Fourth Amendment's warrant requirement. The warrant clause contemplates the warrant applicant be truthful. No warrant shall issue but on probable cause, supported by oath or actions under Supreme Court 1983. When a warrant application is materially false or made in reckless disregard for the Fourth Amendment's warrant clause, a search must not exceed the scope of the search authorized in a warrant by limiting the authorization to search to the specific areas and things for which there is probable cause to search. The Fourth Amendment particularity requirement ensures that the search will be carefully tailored to its justifications and will not take on the character of the wide-ranging exploratory services the framers of the Constitution intended to prohibit. This is a requirement that the police identify themselves to the subject of a search, absent exigent circumstances. Aponte Matos versus Toledo Davila, First Circuit, 1998. Section 9, Due Process. Child's 4-month separation from his parents can be challenged under substantive due process. Sham procedures do not constitute due process. Brokaw versus Mercer County, 7th Circuit, 2000. Post-deprivation remedies do not provide due process if pre-deprivation remedies are practicable. Bendeberg versus Dempsey, 11th Circuit, 1990. Children placed in private foster homes have a substantive due process right to personal security and bodily integrity. Yvonne L. versus New Mexico Department of Human Services, 10th Circuit, 1992. When the state places a child into state-regulated foster care, the state has duties and the failure to perform such duties may create liability under Supreme Court, 1983. Liability may attach when the state has taken custody of a child, regardless of whether the child came to stay with a family on his own, which was not officially approved foster family. Nacini versus Mora, 3rd Circuit, 2000. Social worker who received a telephone accusation of abuse and threatened to remove child from home unless the father himself left, and who did not have grounds to believe the child was in imminent danger of being abused, engaged in an arbitrary abuse of governmental power in ordering the father to leave. Croft versus Westmoreland County, Children and Youth Services, 3rd Circuit, 1997. Plaintiffs were arguable deprived of their right to procedural due process because the intentional use of fraudulent evidence into the procedures used by the state denied them the right to fundamentally fair procedures before having their child removed, a right included in procedural due process. Morris versus Dearborn, 5th Circuit, 1999. When the state deprives parents and children of their right to familial integrity, even in emergency situation, the burden is on the state to initiate prompt judicial proceedings for a post-deprivation hearing, and it is irrelevant that a parent could have hired counsel to force a hearing. K.H. through Murphy versus Morgan, 7th Circuit, 1990. When the state places a child in foster home, it has an obligation to provide adequate medical care, protection, and supervision. Norfleet versus Arkansas, Department of Human Services, 8th Circuit, 1993. Children may not be removed by their home removed from their home by police officers or social workers without notice or hearing, unless the officials have a reasonable belief that the children were in imminent danger. Ram versus Rubin, 9th Circuit, 1997. Absent extraordinary circumstances, a parent has a liberty interest in familial association and privacy that cannot be violated without adequate pre-deprivation procedures. An ex parte hearing based on misrepresentation or omission does not constitute notice and an opportunity to be heard. Procurement of an order to seize a child through distortion, misrepresentation, and or omission is a violation of the Fourth Amendment. Parents may assert their children's Fourth Amendment claim on behalf of their children, as well as asserting their own 14th Amendment claim. Malik versus Arapahoe City Department of Social Services, 10th Circuit, 1999. Plaintiffs' clearly established right to meaningful access to the courts would be violated by suppression of evidence and failure to report evidence. Christie's versus Mississippi Department of Public Welfare, 5th Circuit, 1991. Mother had a clearly established right to an adequate, prompt, post-deprivation hearing. A 17-day period prior to the hearing was not a prompt hearing. Wiseman versus Reinhardt, 8th Circuit, 1997. Section 10. Seizures, child removals. Police officers or social workers may not pick up a child without an investigation or court order. Child removals are seizures under the Fourth Amendment. Seizure is unconstitutional without court order or exigent circumstances. Court order obtained based on knowingly false information violates Fourth Amendment. Brokaw versus Mercer County, 7th Circuit, 2000. Defendant should have investigated further prior to ordering seizure of children based on information he had overheard. Ugh. Everybody got haters. Hurlman versus Rice, 2nd Circuit, 1991. Police officer and social worker may not conduct a warrantless search or seizure in a suspected abuse case absent exigent circumstances. Defendants must have a reason to believe that life or limb is in immediate jeopardy and that the intrusion is reasonably necessary to alleviate that threat. Searches and seizures in investigation of child neglect or child abuse case are at a home are governed by the same principles as other searches and seizures at a home. Good versus Dauphin County Social Services, 3rd Circuit, 1989. Defendants could not lawfully seize a child without a warrant or the existence of probable cause to believe child was in an imminent danger of harm. Where police were not informed of any abuse of the child prior to arriving at the caretaker's home and found no evidence of abuse while there, seizure of the child was not objectively reasonable and violated the clearly established Fourth Amendment rights of the child. Woolley versus City of Baton Rouge, 5th Circuit, 2000. Ooh, Baton Rouge. That's where I was born. For purposes of the Fourth Amendment, a seizure of the person is a situation in which a reasonable person would feel that he is not free to leave, and also either actually yields to a show of authority from police or social workers or is physically touched by the police. Persons may not be seized without a court order and being placed under arrest. California versus Hodari, 499 U.S. 621, 1991. Where the standard for a seizure or search is probable cause, then there must be, I think that's a misprint, there must be particularized information with respect to a specific person. This requirement cannot be undercut or avoided simply by pointing to the fact that, coincidentally, there exists probable cause to arrest or to search or to seize another person or to search a place where the person may happen to be. Yabera versus Illinois, 44 U.S. 85, 1979. An officer who obtains a warrant through material false statements, which results in an unconstitutional seizure, may be held liable personally for his actions under Supreme Court 1983. Aponte Matos versus Toledo de Villa, 1st Circuit, 1998. Section 11, Immunity. Social workers and other government employees may be sued for deprivation of civil rights under 42 U.S.C. Supreme Court 1983 if they are named in their official and an individual capacity. Hafer versus Malo, SCT 1991. State law cannot provide immunity from suit for federal civil rights violations. State law providing immunity from suit for child abuse investigators has no application to suits under Supreme Court 1983. Wallace versus Spencer, Ninth Circuit 1999. If the law was clearly established at the time the action occurred, a police officer is not entitled to assert the defense of qualified immunity based on good faith, since a reasonably competent public official should know the law governing his or her conduct. Harlow versus Fitzgerald, 457 U.S. 800 to 818, 1982. Immunity is defeated if the official took the complaint of action with malicious intention to cause a deprivation of rights, or the official violated clearly established statutory or constitutional rights of which a reasonable person would have known. McCord versus Maggio, 5th Circuit, 1991. A defendant in a civil rights case is not entitled to any immunity if he or she gave false information either in support of an application for search warrant or in presenting evidence to a prosecutor on which the prosecutor based his or her charge against the plaintiff. Young versus Biggers, 5th Circuit, 1991. Police officer was not entitled to absolute immunity for her role in procurement of a court order placing a child in state custody while there was evidence. Officer spoke with the social worker prior to social worker's conversation with the magistrate, and there was evidence that described the collaborative worker of the two defendants in creating a plan of action to deal with the situation. Officers' acts were investigative, and involved more than merely carrying out a judicial order. Malik versus Arapahoe City Department of Social Services, 10th Circuit, 1999. Individuals aren't immune for the result of their official conduct simply because they were enforcing policies or orders. Where statute authorizes official conduct, which is patently violation of fundamental Constitution principles, an officer who enforces that statute is not entitled to qualified immunity. Grossman versus City of Portland, 9th Circuit, 1994. Social workers who were not entitled to absolute immunity for pleadings filed to obtain pickup order for temporary custody prior to formal petition being filed. Social workers were not entitled to absolute immunity where department policy was for social workers to report findings of neglect or abuse to other authorities for further investigation or initiation of court proceedings. Whoa. Social workers investigating claims of child abuse are entitled only to qualified immunity. Assisting in the use of information known to be false in order to further an investigation is not subject to absolute immunity. Social workers are not entitled to qualified immunity on claims they deceived judicial officers in obtaining custody order or deliberately or recklessly incorporated known falsehoods in their report. Ridiculous. Criminal complaints and applications. Use of information known to be false is not reasonable. And acts of deliberately falsity or reckless disregard of the truth are not entitled to qualified immunity. No qualified immunity is available for incorporating allegations into the report or application, where official had no reasonable basis to assume the allegations were true at the time the document was prepared. Snell versus Tunnel, 10th Circuit, 1990. Police officer is not entitled to absolute immunity, only qualified immunity, to claim that he caused the plaintiff to be unlawfully arrested by presenting the judge with an affidavit that failed to establish probable cause. Malley versus Briggs, South Court, 1986. Oh, Supreme Court. 1986. Defendants were not entitled to prosecutorial immunity, where a complaint was based on failure to investigate detaining minor child and an inordinate delay in filing court proceedings, because such actions did not aid in the presentation of a case to the juvenile court. Wiseman versus Reinhardt, 8th Circuit, 1997. Caseworker who intentionally or recklessly withheld potentially as exculpatory information from an adjudicated delinquent or from the court itself was not entitled to qualified immunity. Germany versus Vance, 1st Circuit, 1989. Defendants were not entitled, I can't even read that one, to qualified immunity for conducting warrantless search of home during a child abuse investigation where exigent circumstances were not present. Good versus Dauphin County Services, 3rd Circuit, 1989. Social workers were not entitled to absolute immunity where no court order commanded them to place plaintiff with particular foster caregivers. KH through Murphy versus Morgan, 7th Circuit, 1991. Section 12. Oh, I'm so glad I'm on this side. Decisions of the United States Supreme Court upholding parental rights as fundamental. Paris Adult Theater versus Slayton, 413 U.S. 49.65, 1973. In this case, the court includes the rights of the parents to rear children among rights deemed fundamental. Our prior decisions recognizing a right to privacy guaranteed by the 14th Amendment included only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty. This privacy right encompasses and protects the personal intimacies of the home, the family, the marriage, motherhood, procreation, and child rearing. Pierce versus Society of Sisters, Meyer versus Nebraska. Nothing, however, in this court's decision intimates that there was any fundamental privacy right implicit in the concept of ordered liberty to watch obscene movies and places of public accommodation. Carey versus Population Services International, 431 U.S. 678, 684 to 686, 1977. Once again, the court includes the right of parents in the area of child rearing and education to be a liberty interest, protected by the 14th Amendment, requiring an application of the compelling interest test. Although the Constitution does not explicitly mention any right of privacy, the court has recognized that one aspect of the liberty protected by the Due Process Clause of the 14th Amendment is a right of personal privacy, or a guarantee of certain areas or zones of privacy. This right of personal privacy includes the interest and independence in making certain kinds of important decisions. Where you checking? While the outer limits of this aspect of privacy may not have been marked by the court, it is clear that among the decisions that an individual may make without unjustified government's interference are personal decisions relating to marriage and family relationships. Prince versus Massachusetts, 321 U.S. 158, 1944, and child rearing and education. Pierce versus Society of Sisters, 268 U.S. 510, 1925. Meyer versus Nebraska, 262 U.S. 390, 1923. The court continued by explaining that these rights are not absolute, and certain state interests may at some point become sufficiently compelling to sustain regulation of the factors that govern the abortion decision. Compelling is, of course, the key word, where decisions as fundamental as whether to bear or beget a child is involved. Regulations imposing a burden on it may be justified only by compelling state interest, and must be narrowly drawn to express only those interests. Maher versus Roe, 432 U.S. 464, 476 to 479, 1977. We conclude that the Connecticut regulation does not impinge on the fundamental right recognized in Roe. There is a basic difference between direct state interference with a protected activity and state encouragement of an alternative activity consonant with legislative policy. This distinction is implicit in two cases cited in Roe in support of the pregnant woman's right under the 14th Amendment. In Meyer v. Nebraska, the court held that the teacher's right, thus to teach, and the rights of parents to engage in so, to instruct their children, were within the liberty of the 14th Amendment, In Pierce v. Society of Sisters, the court relied on Meyer, reasoning that the 14th Amendment's concept of liberty excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The court held that the law unreasonably interfered with the liberty of the parents and guardians to direct the upbringing and education of the children under their control. Both cases invalidated substantial restrictions of constitutionally protected liberty interests. In Meyer, the parent's right to have his child taught a particular foreign language. In Pierce, the parent's right to choose private rather than public school education. But neither case denied to a state the policy choice of encouraging the preferred course of action. Pierce casts no shadow over states' power to favor public education by funding it, a policy choice pursued in some states for more than a century. Indeed, Norwood v. Harrison, 413 U.S. 55 to 462, 1973, we explicitly rejected the argument that Pierce established a right of private or parochial schools to share with the public schools in state largesse, noting that it is one thing to say that a state may not prohibit the maintenance of private schools and quite another to say that such schools must, as a matter of equal protection, receive state aid. We think it abundantly clear that a state is not required to show a compelling interest for its policy choice to favor a normal childbirth anymore. Then a state must so justify its election to fund public, but not private education. Although the Maher decision unquestionably recognizes parents' rights as fundamental rights, the court has clearly indicated that private schools do not have a fundamental right to state aid, nor must the state satisfy the compelling interest test if it chooses to give private schools state aid. The Parental Rights and Responsibilities Act simply reaffirms the right of parents to choose private education as fundamental, but it does not make the right to receive public funds a fundamental right. The PRRA, therefore, does not in any way promote or strengthen the concept of educational vouchers. Parham versus Junior, or JR, 442 U.S. 584, 602 to 606, 1979. This case involves a parent's rights to make medical decisions regarding their children's mental health. The lower court had ruled that Georgia's statutory theme of allowing children to be subject to treatment in a state's mental health facilities violated the Constitution because it did not adequately protect children's due process rights. The Supreme Court reversed this decision, upholding the legal presumption that parents act in their children's best interest. The court ruled, our jurisprudence historically has reflected Western civilization concepts of the family as a unit with broad parental authority over minor children. Other cases have consistently followed that course. Our constitutional system long ago rejected any notion that a child is the mere creature of a state, and on the contrary asserted that parents generally have the right, coupled with the high duty, to recognize and prepare for additional obligation. Pierce v. Society of Sisters, 268 U.S. 510 to 535, 1925. The law's concept of the family rests on a presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life's difficult decisions. More importantly, historically, it has been recognized that the natural bonds of affection lead parents to act in the best interest of their children. 1W Blackstone, Commentaries 447. 2J Kent, Commentaries on American Law 190. As with so many other legal presumptions, experience and reality may rebut what the law accepts as a starting point. The incidence of child neglect and abuse cases attests to this. that some parents may at times be acting repugnant to American tradition. Parental rights are clearly upheld in this decision, recognizing the rights of parents to make health decisions for their children. The court continues by explaining the balancing that must take place. Nonetheless, we have recognized that a state is not without constitutional control over parental discretion in dealing with children with their physical or mental health is jeopardized. See Wisconsin versus Yoder, Prince versus Massachusetts. Moreover, the court recently declared unconstitutional a state statute that granted parents an absolute veto over a minor child's decisions to have an abortion. Planned Parenthood of Central Missouri versus Danforth, 428 U.S. 52, 1976. Appellees urged that these precedents limiting the traditional rights of parents, if viewed in the context of a liberty interest of the child and the likelihood of parental abuse, require us to hold that parents' decision to have child admitted to a mental hospital must be subjected to an exacting constitutional scrutiny, including a formal adversary pre-admission hearing. Appellee's arguments, however, sweeps too broadly. Simply because the decision of a parent is not agreeable to a child or because it involves risks does not automatically transfer power to make that decision from the parents to some agency or officer or of the state. The same characterizations can be made for the tonsillectomy, appendectomy, or other medical procedure. Most children, even in adolescence, simply are not able to make sound judgments concerning many decisions, including their need for medical care or treatment. Parents can and must make those judgments. We cannot assume that the result in Meyer versus Nebraska, Supra, and the Pierce versus Society of Sisters, Supra, would have been different if the children there had announced or preference to go public rather than a church school. The fact that a child may balk at hospitalization or complain about parental refusal to provide cosmetic surgery does not diminish the parent's authority to decide what is best for the child. See Generally Goldstein, medical case for the child at risk on state supervision of parental autonomy, 86 Yale, LJ 645, 664 to 668, 1977. Bennett, allocation of a child medical care decision, making authority, a suggested interest analysis, 62, VALR-EV, 285-308, 1976. Neither state official nor federal courts are equipped to review such parental decisions. Therefore, it is clear that the court is recognizing parents as having the right to make judgments concerning their children who are not able to make sound decisions, including their need for medical care. A parent's authority to decide what is best for the child in the areas of medical treatment cannot be diminished simply because a child disagrees. A parent's right must be protected and not simply transferred to some state agency. City of Akron versus Akron Center for Reproductive Health, Incorporated, 462 U.S. 461, 1983. This case includes, in a long list of protected liberties and fundamental rights, the parental rights guaranteed under Pearson Meyer. The court indicated a compelling interest test must be applied. Central among these protected liberties is an individual's freedom of personal choice in matters of marriage and family life, Roe, Griswold, Pierce versus Society of Sisters, Meyer versus Nebraska, but restrictive state regulation of the right to choose abortion, as with other fundamental rights subject to searching judicial examination, must be supported by a compelling state interest. Santosky versus Kramer, 455 U.S. 745, 753, 1982. This case involved the Appellate Division of New York Supreme Court affirming the application of the preponderance of the evidence standard as proper and constitutional and ruling that the parent's rights are permanently terminated. The U.S. Supreme Court, however, vacated the lower court decision, holding that due process is required under the 14th Amendment. In this case, required proof by clear and convincing evidence rather than merely a preponderance of the evidence. The court, reaching their decision, made it clear that parents' rights, as outlined in Pearson Meyer, are fundamental and specially protected under the 14th Amendment. The court began by quoting another Supreme Court case. In Lassiter versus Department of Social Services, 452 U.S. 18.37, 1981. It was not disputed that state intervention to terminate the relationship between a parent and child must be accompanied by procedures meeting the requisites of the Due Process Clause. The absence of dispute reflected this court's historical recognition that freedom of personal choice in matters of family life is a fundamental liberty interest protected by the 14th Amendment. Pierce versus Society of Sisters, Meyer versus Nebraska. The fundamental liberty interest of natural parents in the care, custody, and management of their child does not evaporate simply because they have not been model parents or have lost temporary custody of their child to the state. When the state moves to destroy weakened familial bonds, it must provide the parents with fundamentally fair procedures. Oh, do they? Fair procedures? Ah, we got a shot. All right. Lair versus Robertson, 463 U.S. 248, 257 to 258, 1983. In this case, the U.S. Supreme Court upheld a decision against a natural father's rights under due process and equal protection clauses since he did not have any significant custodial, personal, or financial relationship with the child. The natural father was challenging an adoption. The Supreme Court stated, in some cases, however, the court has held that the federal Constitution supersedes state law and provides even greater protection for certain formal family relationships. In those cases, the court has emphasized the paramount interest in the welfare of the children and has noted that the rights of the parents are counterpart of the responsibilities they have assumed. Thus, the liberty of parents to control the education of their children that was vindicated in Meyer versus Nebraska and Pierce versus Society of Sisters was described as a right coupled with the high duty to recognize and prepare a child for additional obligations. The linkage between parental duty and parental right was stressed again in Prince versus Massachusetts. The court declared it a cardinal principle that the custody, care, nurture of the child reside first in the parents whose primary function and freedom include preparation for obligations the state can neither supply nor hinder. In these cases, the court has found that the relationship of love and duty in a recognized family unit is an interest in liberty entitled to constitutional protection. State intervention to terminate such a relationship must be accompanied by procedures meeting the requisites of the Due Process Clause. It is clear by the above case that the parental rights are to be treated as fundamental and cannot be taken away without meeting the constitutional requirements of due process. Board of Directors of Rotary International versus Rotary Club of Duarte, 481 U.S. 537, 1987. In this case, a Californian civil rights statute was held not to violate the First Amendment by requiring an all-male nonprofit club to admit women to membership. The court concluded that parents' rights in child-rearing and education are included as fundamental elements of liberty protected by the Bill of Rights. The constitutional protection include marriage, the begetting and bearing of children, child rearing and education, Pierce versus Society of Sisters. Michael H. versus Gerald, 491 U.S. 110, 1989. In a paternity suit, the United States Supreme Court ruled it is an established part of our constitutional jurisprudence that the liberty in the Due Process Clause extends beyond freedom from physical restraint. C.E.G. Pierce versus Society of Sisters, Meyer versus Nebraska. In an attempt to limit and guide interpretation of the clause, we have insisted not merely that the interest denominated as a liberty be fundamental, a concept that, in isolation, it's hard to objectify, but also that it be an interest traditionally protected by our society. As we have put it, the Due Process Clause affords only those protections so rooted in the traditions and conscience of our people as to be ranked as fundamental. Snyder versus Massachusetts, 291 U.S. 97.105, 1934. The court explicitly included the parental rights under Pierce and Meyer as fundamental and interests traditionally protected by our society. Employment Division of Oregon versus Smith, 494 U.S. 872, 1990. One of the more recent decisions which upholds the right of parents is Employment Division of Oregon versus Smith. which involved 2 Indians who were fired from a private drug rehabilitation organization because they ingested peyote, a hallucinogenic drug, as part of their religious beliefs. When they sought unemployment compensation, they were denied because they were discharged for misconduct. The Indians appealed to the Oregon Court of Appeals, who reversed on the grounds that they had the right to freely exercise their religious beliefs by taking drugs. Of course, as expected, the United States Supreme Court reversed this case and found that the First Amendment did not protect drug use. So, what does this case have to do with parental rights? After the court ruled against the Indians, it then analyzed the application of the Free Exercise Clause generally. The court wrongly decided to throw out the Free Exercise Clause as a defense to any neutral law that might violate an individual's religious convictions. In the process of destroying religious freedom, the court went out of its way to say that parents' rights to control the education of their children is still a fundamental right. The court declared that the compelling interest test is still applicable, not to the Free Exercise Clause alone. But the Free Exercise Clause, in conjunction with other constitutional protections, such as the rights of the parents, acknowledged in Pierce v. Society of Sisters 268 U.S. 510, 1925, to direct the education of their children, see Wisconsin v. Yoder 406 U.S. 205, 1972, invalidating compulsory attendance laws as applied to Amish parents who refuse religious grounds to send their children to school. In other words, under this precedent, parents' rights to control the education of their children is considered a constitutionally protected right, which requires the application of the compelling interest test. The court in Smith quoted its previous case of Wisconsin versus Yoder. Yoder said that the court's holding in Pierce stands as a charter for the rights of parents to direct the religious upbringing of their children. And when interests of parenthood are combined with free exercise claim, more than merely a reasonable relationship to some purpose with the competency of the state is required to sustain the validity of the state's requirement under the First Amendment. 406 U.S. at 233.20. Instead of merely showing that a regulation conflicting with parents' rights is reasonable, the state must therefore reach the higher standard of the compelling interest test, which requires the state to prove its regulation to be the least restrictive means. Hodgson versus Minnesota 497 U.S. 417, 1990. In Hodgson, the court found that parental rights are not only protected under the First and 14th Amendments as fundamental and more important than property rights, but that they are deemed essential. Essential. Yeah. The family has a privacy interest in the upbringing and education of children and the intimacies of the marital relationship, which is protected by the Constitution against undue state interference. See Wisconsin versus Yoder 7-406 U.S. 205. The statist notion that a governmental power should supersede parental authority in all cases because some parents abuse it and neglect their children is repugnant to American tradition. In other words, under this precedent, parents' rights to control the education of their children is considered a constitutionally protected right, which requires the application of the compelling interest test. The court in Smith quoted his previous case of Wisconsin versus Yoder again. Yoder said that the court's holding in Pierce stands as a charter for the rights of parents to direct the religious upbringing of their children. And when the interests of parenthood are combined with free exercise claim more than merely a reasonable relationship to some purpose within the competency of the state is required to sustain the validity of the state's requirement under the First Amendment. 406 U.S. at 233.20. Did I read right? Instead of merely showing that a regulation conflicting with parents' rights is reasonable, the state must therefore reach the higher standard of the compelling interest test, which requires that the state prove its regulation to be the least restrictive means. I swear I just read that. I did. That was written twice. Anyways. Hodgson versus Minnesota 497 U.S. 417, 1990. Oh. Wow, this is duplicated again. I'm not reading it again. Hold up. I don't know. I don't see the reason. Supersede parental authorities. I don't know.
Maybe a different finding in this one.
We have long held that there exists a private realm of family life which the state cannot enter. That's Parham 442 U.S. at 603. A natural parent who has demonstrated sufficient commitment to his or her children is therefore entitled to raise her children free from undue state interference. As Justice White explained in this opinion of the court in Stanley v. Illinois 405 U.S. 645, 1972, rights are far more precious than property rights. The integrity of the family unit has found protection in the Due Process Clause of the 14th Amendment. The court leaves no room for doubt as to the importance and protection of rights of parents. H.L. versus Matheson, 450 U.S. 398, 410, 1991. In this case, the Supreme Court recognized the parent's right to know about their child seeking abortion. Court stated, in addition, constitutional interpretation has consistently recognized that the parent's claim to authority in their own household to direct the rearing of their children is basic in the structure of our society. Ginsburg versus New York, 390 U.S. 629, 1968. We have recognized on numerous occasions that the relationship between the parent and the child is constitutionally protected. It is cardinal with us that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom includes preparation for obligations the state can neither supply nor hinder. We have recognized that parents have an important guiding role to play in the upbringing of their children, which presumptively includes counseling them on important decisions. This court clearly upholds the parent's right to know in the area of minor children making medical decisions. Vernonia School District 47J versus Acton 132 LED 2D 564 115. Supreme Court 2386 1995. In Vernonia, the court strengthened parental rights by approaching the issue from a different point of view. They reasoned that children do not have many of the rights accorded to citizens, and in lack thereof, parents and guardians possess and exercise those rights and authorities in the child's best interest. Traditionally, at common law, and still today, unemancipated minors lack some of the most fundamental rights of self-determination, including even the rights of liberty in its narrow sense, the right to come and go as will. They are subject even to their physical freedom, to the control of their parents or guardians. Troxel versus Granville, 530 U.S. 57, 2000. In this case, the United States Supreme Court issued a landmark opinion on parental liberty. This case involved a Washington state statute which provided a court may order visitation rights for any person when visitation may serve the best interests of the child. Whether or not there has been any change of circumstances, Washington Revised Code, Supreme Court 26.10.163.3. The U.S. Supreme Court ruled that the Washington statute unconstitutionally interferes with the fundamental rights of the parents to rear their children. The court went on to examine its treatment of parental rights in previous cases. In subsequent cases also, we have recognized the fundamental right of parents to make decisions concerning the care, custody, and control of their children. Wisconsin versus Yoder 406, U.S. 205, 232, 32, LED, 2, 2D, I said LED, it was LED, 2D, 15.92, Supreme Court, 1526, 1972. Thank you. The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture, and this case clearly upholds parental rights. In essence, the decision means that the government may not infringe on parents' rights to direct education or upbringing of their children unless it can show that it is using the least restrictive means to achieve a compelling government interest. Conclusion. The U.S. Supreme Court has consistently protected parental rights, including it among those rights deemed fundamental. As a fundamental right, parental liberty is to be protected by the highest standard of review, the compelling interest test. As can be seen from the cases described above, parental rights have reached their highest level of protection in over 75 years. The court decisively confirmed these rights In the recent case of Troxel versus Granville, which should serve to maintain and protect parental rights for many years to come. I felt like that this video was absolutely necessary for those of you that got that knock on the door and didn't know. Don't sign anything. Don't trust them. They are liars. They will try to kidnap your kids. And I know this because I've done everything these people have asked me to do. And I've been here since January dealing with them. All because I got a call. I'm the non-offending parent. They do not have reunification as a goal. It doesn't matter if you got an apartment under your name with a room just for him. It doesn't matter. They want to keep your kid as a paycheck. And whatever they hear about you, they're just automatically, I don't know, assuming that it's true. I don't care. I know now I have rights. And it feels good to know that I have rights.